Welcome to Do It for the Case Law for Monday, July 27th, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Today, the docket is substantial with 80 cases across 9 circuits. Our team will cover criminal justice, including drug trafficking and firearms, civil rights matters ranging from employment discrimination to Section 1983 claims, Supreme Court and constitutional law updates, business and labor disputes, as well as immigration and government agency reviews. Please subscribe to stay updated on federal appellate developments. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. 30 cases in this block. 21 were affirmed, 3 dismissed, 2 vacated and remanded, 1 split outcome, and 3 denied or terminated without reaching the merits. We start with the reversals and splits. In the Fourth Circuit, Kennedy Jackie's sentence was vacated and remanded because the district court wrongly denied her Sixth Amendment right to self-representation at sentencing. A pre-sentencing request for pro se representation is timely if clear and unequivocal. Also in the Fourth, DeMichael Peoples received a new sentencing hearing after the district court failed to orally pronounce all supervised release conditions required by criminal procedure rules, adding location monitoring costs in the written judgment that were never spoken. The split outcome came from Chetty White's conviction being affirmed while his appeal on certain waiver issues was dismissed, and from Jamile Birch, where the court dismissed challenges barred by a valid plea agreement waiver but affirmed the supervised release portion. In the Ninth Circuit, James Patterson's mandatory minimum sentence under the Armed Career Criminal Act was affirmed despite an Apprendi error. The court found the mistake harmless because overwhelming evidence showed his prior crimes occurred on different occasions. Moving to the 11th Circuit, Jeffrey Ryan Clark and co-defendants had their convictions affirmed while one aspect of the sentencing review was reversed due to insufficient explanation of the variance. 3 cases in the Fourth Circuit were dismissed. Seymour Othman's appeal was barred for being untimely filed. Devonta Fontenot's supervised release revocation was affirmed after a procedural review, and True Heaven Heflin's appeal on waived issues was dismissed while her conviction stood. In the 11th Circuit, multiple appeals were affirmed without argument, including Shakira English under an Anders review where counsel withdrew, Jeremiah Travis, whose motion for relief from judgment was partially dismissed as untimely, Doga Yo's supervised release revocation sentence, Angela Chu's bribery and fraud convictions, and Marco Vedo's illegal re-entry sentence. The Fifth Circuit saw Adam Arredondo's appeal dismissed after appointed counsel filed an Anders brief finding no non-frivolous issues. 2 defendants with identical 400-month sentences for methamphetamine distribution and felon in possession charges were affirmed in the Fifth Circuit. Both faced a 2-level enhancement for maintaining a premises used for drug distribution, which the court found supported by reasonable inferences from the evidence. Jared Carter's felon in possession conviction was affirmed after his constitutional challenges to the statute were rejected under binding precedent. Josue Otero Garay's illegal re-entry sentence was affirmed via summary judgment because his challenge to the sentencing enhancement was foreclosed by Supreme Court precedent. William Hardin's judgment was modified to correct standard conditions of supervised release regarding residence notification and employment requirements. In the Sixth Circuit, Sabrina Garcia's appeal was dismissed as to her ineffective assistance claim for being premature, while her 30-month sentence was affirmed due to a valid plea waiver. The Seventh Circuit affirmed Stephen Dorfman's fraud convictions after rejecting arguments about jury instructions on scheme to defraud, noting that misleading omissions can constitute fraud without express falsehoods. In the Eighth Circuit, Brandon Castillo and Rodolfo Urita Barba received affirmed sentences within the guidelines for ammunition and drug offenses, respectively, with courts finding no abuse of discretion in denying variances. Anthony Alguin's below-guidelines sentence was affirmed after appointed counsel withdrew under Anders procedures, finding no meritorious issues. Sterling George Spotted Elk Jr.'s motion for sentence reduction was denied because his serious criminal history and prison infractions outweighed any rehabilitative efforts claimed. The Ninth Circuit also affirmed Mark Anton's conviction for transmitting threats, clarifying that the statute requires both an objective reasonable person standard and a subjective mental state of knowing or conscious disregard. Back to you, David.
Thanks, James. Now for civil rights and employment matters, let's turn to Aisha.
Thanks, David. I have 18 cases from the 10th, 11th, 4th, 6th, 7th, 8th, and 9th circuits to cover. In this block, 14 were affirmed, 1 was dismissed, 1 was reversed and remanded, and 3 were split outcomes with a reversal in part and affirmation in part. We begin with the split outcome from the 8th Circuit. The court reviewed a Section 1983 excessive force case involving pretrial detainees at the city of St. Louis. While the court affirmed the denial of qualified immunity for Lieutenant Falks regarding 3 specific incidents where officers sprayed mace on restrained and non-resisting individuals, the ruling included a partial reversal that clarified the scope of liability for other defendants not mentioned in the affirmation. Moving to the Ninth Circuit, the court reversed and remanded Michael Mitchum's case against Butte County. The appellate court held that his pro se complaint plausibly stated a claim under Title II of the Americans with Disabilities Act, finding he sufficiently alleged deliberate indifference regarding meaningful access to jail services, rejecting the lower court's dismissal. Over in the 10th Circuit, the court affirmed summary judgment for Catherine Trujillo against her Landlord on Fair Housing Act claims. The court established that the aided by agency exception to vicarious liability is narrow, requiring a specific causal nexus where employment actually aided the employee in committing the tort, which Trujillo failed to prove regarding a rape committed by an employee. Also in the 10th Circuit, the court affirmed summary judgment for state officials against the American Car Rental Association. The court held that Colorado's congestion impact fee is not preempted by the federal Anti-Head Tax Act because the fee targets consumers renting vehicles rather than the businesses themselves. In the 11th Circuit, the court affirmed the return of a minor child to Norway under the Hague Convention in William Mendoza Berg versus Socorro del Carmen Polanco Sandoval. The father established that the child habitually resided in Norway and that his retention was wrongful, while the mother's grave risk defense was rejected due to evidence of Norway's protective systems. The 11th Circuit also affirmed summary judgment for Sumter County, Georgia, against Rhonda Jackson on her discrimination and retaliation claims under the Americans with Disabilities Act. The court found the timing of her termination too distant from her disclosure of disability to support an inference of intentional discrimination. Additionally, the 11th Circuit affirmed the dismissal of Willie Bruce Bryant's Section 1983 complaint against a prosecutor and sheriff's deputies. The court ruled that the prosecutor had absolute immunity for judicial phase conduct, while the law enforcement officers were entitled to qualified immunity. Turning to the 4th Circuit, we have a mix of outcomes including one dismissal for lack of jurisdiction. The court dismissed the appeal filed by John T. and Aisha Johnson, covering civil rights and constitutional law. The 3rd Circuit issued a powerful opinion today on equal protection in public school funding. The court held that Pennsylvania's school funding formula violates the Equal Protection Clause by systematically underfunding districts with high concentrations of minority students. The court found no reversible error in the district court's ruling dismissing the plaintiff's case without oral argument. 3 other cases in the 4th Circuit were affirmed or dismissed for procedural failures. Chauncey Demetrius Bennett's Section 1983 complaint was dismissed for failure to state a claim and noncompliance with prior court instructions. Michael T. Moore's civil rights complaint was also dismissed under Federal Rule 12 for failing to state a claim, and Jay False's action was affirmed after summary judgment because his informal brief failed to preserve the necessary arguments for appellate review. Moving to the 6th Circuit, the court affirmed summary judgment for the Department of Veterans Affairs against Tara Miller on her Title VII and Age Discrimination in Employment Act claims. The plaintiff waived her arguments on appeal by failing to address essential elements in her opposition brief, and the record lacked evidence that she was treated less favorably than similarly situated employees. Also in the 6th Circuit, the court affirmed the denial of a preliminary injunction based on the Younger abstention doctrine in a case involving Holly Hooven. The federal court must abstain from interfering with pending state domestic relations proceedings that implicate important state interests. In the 7th Circuit, the court affirmed summary judgment for the Wisconsin Department of Corrections against Stanley L. Felton. The court held that his statement to his son about an upcoming prison search was purely private and not a matter of public concern, meaning it received no First Amendment protection. Finally, in the 9th Circuit, the court affirmed summary judgment for the Welpenit School District against David Krasny in a whistleblower retaliation case. The court applied an objective reasonable belief standard under the National Defense Authorization Act, finding that Krasny's disclosure did not meet the statutory requirements for protected activity. That covers the civil rights and employment docket for today. Back to you, David.
Thanks, Aisha. Let's turn to Michael covering Supreme Court and constitutional law.
Thanks, David. In this block of 10 cases from the 4th and 5th Circuits, we had 4 dismissals, 5 affirmances, 1 split outcome with partial reversal, and 2 vacators remanded for new proceedings. First, the 4th Circuit saw 2 significant movements. Donald Wayne Barksdale's civil rights action was vacated and remanded because he only has 2 valid strikes under the Prison Litigation Reform Act, allowing him to proceed without prepaying fees, and in United States v. Melvin, the sentence was vacated and remanded because the government introduced a new Armed Career Criminal Act predicate offense at sentencing after missing the 14-day objection deadline. Moving to the 5th Circuit, Jose Manuel Suarez's 8th Amendment claims against prison officials for failure to protect him from violence were partially reversed. as the court found plausible allegations of deliberate indifference regarding understaffing and safety risks. The remaining cases in this block involved routine dismissals or affirmances. Amaro Edward Barnes was dismissed for lack of jurisdiction after a magistrate judge's recommendation. Donald H. Kimball was affirmed on dismissal for failure to state a claim. Travis Santel Howell's conviction and supervised release conditions were affirmed without oral argument. Stephen Niven's habeas petition was dismissed for lack of jurisdiction. Justin Godfrey Faringer's appeal was denied a certificate of appealability. Samuel L. Harris's appeal was dismissed for failing to show debatable constitutional issues, and William Lee Anderson II's successive habeas petition was dismissed for the same reason. Back to you, David.
Thanks, Michael. Let's turn to Maria covering business, labor, and civil law.
Thanks, David. Maria Santos with 15 cases from the 1st through 8th circuits. The disposition roll-up shows 1 reversal, 2 vacators with remands, and 12 affirmances or dismissals. Starting with the reversals and movements, the 7th Circuit reversed a dismissal in a consumer protection case against Chobani, holding that plaintiffs plausibly alleged deceptive marketing regarding allulose labeling and that such claims are not preempted by the federal food statute. The 6th Circuit vacated summary judgment for an engineering firm in a construction dispute, ruling that a settlement agreement did not waive negligence or breach of contract claims, where the engineer had separate duties distinct from its co-defendant's design work. In the 8th Circuit, the court vacated and remanded an insurance coverage dispute involving hail damage to roofs, finding a factual question exists over whether the damage impaired the roof's functional capacity to resist wind and snow loads despite no active leakage. Moving to the 1st Circuit, 3 errata sheets corrected clerical errors in prior opinions for Chirino v. General Electric, Rana v. Blanche, and United States v. Volcar, clarifying text without altering substantive holdings. The 10th Circuit affirmed summary judgment for Ephraim Olson in a legal fee dispute, holding that attorney fees are not recoverable as special damages under the American rule when no third-party litigation exception applies, and also affirmed dismissal of a defamation claim against filmmaker Catherine Kubler regarding a Netflix documentary.
In the 4th Circuit, the court affirmed procedural dismissals for Olivia Johnson and Jerome Burnett for failing to meet filing requirements or state their claims, and upheld a denial of immigration benefits for parents of special immigrant juvenile status holders, finding a statutory bar prevents such benefits regardless of parental conduct. The 5th Circuit affirmed dismissal of Stephen Maggie's contract and trademark claims, ruling that piercing the corporate veil requires proof of actual fraud for direct personal benefit under Texas law. Finally, in the 7th Circuit, the court affirmed summary judgment for Frederick Health in a class action over overtime pay calculations, confirming that dividing total remuneration by total hours worked is a lawful method under federal regulations. Back to you, David.
Thanks, Maria. Now for immigration and government law, let's turn to Raj.
Thanks, David. Today we have 7 cases from the 11th, 4th, and 6th circuits covering immigration appeals, administrative agency review, and civil procedure. In terms of dispositions, 2 petitions were dismissed, 3 judgments were affirmed, 1 was denied, and 1 case was vacated and remanded. We begin with a split outcome in the 6th Circuit where the court vacated a district court decision regarding a Medicare safe harbor defense and remanded for a new determination by the administrative law judge. The court held that the judge applied an incorrect legal standard by concluding a provider is automatically disqualified simply because it knew of Medicare notices, ruling instead that the proper inquiry is whether the provider did not know of specific standards. Moving to the 11th Circuit, the court denied a petition for review in the matter involving Danny Leo Valdivia Alaman and his family seeking asylum, withholding of removal, and protection under the United Nations Convention Against Torture. The court affirmed the Board of Immigration Appeals' adverse credibility finding, noting that an adverse credibility determination alone can support a denial if supported by specific reasons, and held that the petitioners failed to exhaust administrative remedies regarding several inconsistencies cited by the immigration judge. Also in the 11th Circuit, the court dismissed Rosa Peralta's appeal for lack of subject matter jurisdiction because the Board of Immigration Appeals affirmed the lower decision solely as a matter of ultimate discretion without addressing statutory eligibility or the extreme hardship standard. Over in the 4th Circuit, 3 cases were disposed of without oral argument. The court affirmed Kent J. Ashton's dismissal for lack of standing due to failure to demonstrate concrete injury, and it also affirmed the denial of a Rule 60 motion for reconsideration, where the notice of appeal was filed too late to challenge the underlying jurisdictional dismissal. Additionally, the 4th Circuit dismissed an Internal Revenue Service appeal because the magistrate judge's order was not a final appealable order under federal statute, since the parties had not consented to its jurisdiction. Finally, the 4th Circuit dismissed Joan Sicchiello's appeal for failure to file timely objections to a magistrate judge's recommendation regarding res judicata. Back to you, David.
That wraps up today's broadcast for Monday, July 27th, 2026. Thank you to James Taylor for covering 30 cases on criminal justice, Aisha Johnson for 18 civil rights cases, Michael Reeves for 10 constitutional law opinions, Maria Santos for 15 business and labor matters, and Raj Patel for 7 immigration and government appeals. Today's docket featured 1 significant reversal or remand, 50 affirmances, 15 other dispositions, and 14 dismissals. Several appeals were dismissed on procedural grounds. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Please subscribe and follow us for daily updates.